am not preempting the hearing and determination of the subsequent application, but I wish to bring it to your attention that the issue of legal representation is one that must be considered alongside bail and bond, because since you have addressed the court on bail and bond, we must ensure that all parties have been represented to the extent of that application. About the hearing, I'm nowhere near. I'm still on the bail and bond, so that this application will be considered by this court only to the extent of bail and bond. And if we find that we have not heard from them, then we hear from them on the issue of bail and bond. In light of that, I hear you that the accused person's constitutional right should also be taken into account. So I'll be asking all parties to expedite in exercising our rights. The quorum shows that I also want my lawyer to be heard. So I can't pretend that I know these persons, and you bear with me that this matter is being handled by this court physically for the first time today. So allow me, if I look like I'm delaying you, so that we bring everybody on board and we proceed. First and foremost, with the application of bail and bond.
Yes. And my lady, if you allow me, this is the challenge.
Yes.
The victim's family have also put in another application, a notice of preliminary objection. And I'm afraid, my lady, when we come before you again the next time, they will say that we entertain in respect to that application.
I'm not aware of any application of preliminary objection.
And my lady, respectfully, I intervene that this victim's family counsel, not an important matter at the state. The people closest with that jurisdiction, my lady, is the ODPP. I'm afraid when we come before you again on the issue of representation, counsel will still ask that we may have on this notice of preliminary objection.
Is there a preliminary objection that has been filed?
Yes.
Wait, hold on, Mr. Yegon. Just hold on, Mr. Yegon. Just a minute. Let me find affidavit in response to the affidavit to oppose bail and bond, dated 24th, filed on 10th September, for purposes of bail and bond. And then there is a photocopy document by ODPP of 24th July 2025 of disclosure checklist. Duty court proceedings of 26th August 2025.
Ladies, that the application for bail is fatally defective. Yes, it is defective because...
Wait. We are still on availing the PO.
Right.
Yeah?
Yes.
I believe in seeing. I don't believe in just being told. So I have not seen the preliminary objection.
That have not also been served with the preliminary objection. I have just heard from counsel for the defense that there is a preliminary objection. We are yet to be served, my lady.
Because it is clear, counsel, the victim's family, they want to buy time to the lady, yes. And it is so surprising that they should be here now.
On our behalf.
The application,
I
my
was just
lady,
saying that we have not received the preliminary objection.
if
And we
perhaps, my lady, if the DPP and Mr. Yegon would allow us to speak. And it is simply on the issue that that application cannot and should not be considered by this court because it is fatally defective. The application is supported by an affidavit which has been commissioned by Mr. Felix Keaton, who came on record for the accused person.
Who is Felix Keaton? Is he?
Yes, it is in your record. He came on record on the 28th.
Remember, I've told you today is the first day I'm seeing this physical file. Remember, I was online.
Okay.
Mm-hmm.
Yes.
Today, which Mr. Egon says he has seen, but Ms. Tum for ODPP has not seen.
Yes.
So let me record that fact first.
Very well.
And have not seen the PO, and you have now served a physical copy to the court.
Yes.
My lady, for the record.
Yeah, just a minute.
This is Mrs. Bobo from my farm.
Yes, just a minute. Let us move systematically. This is Ms. Manjera.
Yes, my lady.
For the accused person, Ms. Tum for ODPP and Ms. Mbugwa for IPOA have not received the same. Is that the true position?
Your Honor, it's not that. I've actually seen I saw the notice this morning, the notice of criminal investigation, and I have 3 quick observations.
No, we're still on service. Remember? First, we see the application. No, you can choose. If you want to be served physically with a copy, you're entitled to. But I'm saying we have a checklist. First, we see and identify the application. Then, we move to the next stage, that each one of us has the right to respond. Yeah? So, for today, I'm saying that I have now received a copy, and a copy shall also be served to the ODPP and IPOA and the defense, all right, for purposes of responding.
Before you pen off your final order.
No, I've not even reached final orders, Mr. Yegon. Today we have the application of 6th August, served to all parties, and they are at liberty to respond. And then the notice of preliminary objection is also served to all parties, and they are at liberty to respond. And then that should take us 14 days, I hope. I want us to build consensus on this. 14 days, is that sufficient, ODPP?
My lady, it's sufficient for us.
IPOA?
My lady, that is sufficient.
Defense Counsel?
Yes, my lady.
Is 14 days sufficient for each of the parties to serve and be served the application of 6th August and notice of preliminary objection, and each party to file their response or responses?
My lady, for that person, is the notice of preliminary objection, that is for the issue that were within the affidavit of the accused person. And in trying to save time, the precious judicial time, my lady, I have actually amended the affidavit, the supporting affidavit, and the replying affidavit, and I have filed it in court. So, my lady, I humbly submit that there is no need to continue hearing this application of notice preliminary objection, since we have already rectified the mischief that the
Mr. Yegon, we are all bound by Article 50. All of us, me included. So mine is to receive every application, to ensure it is served to all parties, and to ensure the parties have been given a chance to respond. Once I lay out that right, then each of you is at liberty to tell me, Judge, we don't need to hear the application, we have resolved, then I write, then we move to the next. All parties should tell me that, not one. So I'll leave it to your good selves. If you feel it is something you can resolve, amend, agree on, you just tell the court, we have agreed. But my role is to ensure all of us have received whatever application and have responded. Then when you tell me you have agreed, amended, resolved, then I now fall back on the bail and bond application, and whether the applicant, Susan somebody, will address us. I think that's the only person who did not address us during the bail and bond application.
My lady, just amended it.
let them respond.
Very well.
And we cannot record what we have not seen. Remember, I have to see, so that tomorrow when I'm not here, whoever looks at the file will be able to see what I looked at. All right?
Very well.
So for now, I've only seen 2 applications, the one of 6th of August and the PO. Physically, I've seen them. So it is service and response, then we take it from there. You want to decide. So engage your colleagues and then tell me when you're ready, I'll mention it again. Are we through with our matters?
Yes.
Okay, so I'll adjourn and then you'll be able to tell me.
I have already
Is it working? Yes. Who is addressing the court? Yes?
My lady, we've had, and he has told me that he's also having similar discussions with the other players. So I believe he's best placed to tell you what we've agreed.
Can address the court.
We are going to abandon our PO to the extent that
Am I supposed to hear that, counsel?
But my lady, you've
I'm
asked
not
me.
supposed to hear the bargain. I'm supposed to hear the official part, the legal part, because I can't record in exchange for one not hearing. So that was the discussion. That's why I used the word consensus. Now tell me at the end, what have you agreed? Not who gave what for what.
most obliged. So we've agreed that the responses we filed earlier regarding the application for bail be considered as responses to the new application, the one that they have rectified. And the Victims' Council will file submissions on that issue. We can get a ruling date.
For what now?
For bail.
I was going to write the ruling. You forgot it.
Yes.
Let me just remind you, because there are only 2 issues, and they will come on record, we'll repeat what we are saying. On 19th of August, was addressed with regards to bail by Mr. Egon on the accused's application of 15th August 2025. Okay?
Yes.
And then Mr. Ngatia also addressed the court with regard to the notice of motion of 29 July 2025 and related to the case of Lendrix Waswa and sought clarification and the court to cement the role of victims in this case in line with Article 27, Article 50Q of the Constitution and Section 4, 9 and 13 of the Victim Protection Act. Then we had Ms. Kirigo, ODPP, who said they filed an affidavit by IPOA of 24th July and served all parties. And then the court directions were that Mr. Egon requested for 14 days to respond to the application, filed and served within 14 days. Mr. Ngatia to also have the same within 14 days. And if parties wished, they would also file written submissions. That is as per the proceedings of 19th August.
Yes, my lady. Then the issue of that defective application, which now has come up today, would have meant that, first of all, we argue on whether that application can even be entertained as it is, having been commissioned by an advocate who was on record for the accused person. So with my colleague informing me that he has tried to remedy the situation by filing a new application, then we have agreed that defense does not oppose participation of the victim in these proceedings fully, while we will not oppose them filing the new application, and for the responses we had filed earlier to be considered the responses for this new application, so that we can proceed to get the ruling as the court
There's
has.
still a place you have missed. So up to that point, what you've just said now makes sense.
Yes.
So if then the defense is not objecting to your application for Susan, the name, whoever the applicant,
Yes.
to address the court, and you in return are not objecting to them regularizing their pleadings,
Yes.
then should it the next step be that now the applicant can address the court on bail and bond, now that you have conceded to that application?
Precisely, my lady. And which is why the next part of our agreement was we be allowed to file submissions on that issue of bail and bond. Because earlier,
No, it's okay. It's okay.
yes,
At least now there will be submissions. Then
Yes.
I can now proceed to
Yes.
deal with the issue of bail.
yes, my lady,
Okay.
Yes,
So
ma'am.
let's hear from him,
yes,
and then I'll record.
yes,
Because
my
it
lady.
sounds like it's a consent,
Yes,
isn't it?
yes, my lady.
Okay.
Thank you.
Who want to address the court?
My name
Who?
is Ishore for the state.
Yes.
Ms. Ishore,
Yes.
we have not been consulted by any party. That's why we are hesitant to know what has happened, because the defendants have not contacted us.
You have not been consulted by any party on the current subject, eh? Yes.
If the evidence is that the victim has served the videos. Because that were actually just coming for the day of you. But my apologies has not been called. I am not having a collision with you. Of president.
This morning is that I explained why the ruling for bail and bond sought by the applicant was not written, and this is the fact of the application that was brought to this court's attention on 26th of August. That is the application by one Susan Jerry Kariuki. The application was filed on 6th August and brought to the court's attention on 26th of August. That application relates to legal representation of victims and how far, what are the parameters of the same. So at that point, I stopped pursuing and preparing the ruling for bail and bond, and sought that the matter is mentioned today so that I would confirm service of that application and allow parties the opportunity to respond. Then we can move back to the bail and bond application. So this morning, the court was informed that that application was not served to the respective parties, ODPP, IPOA, and the defense. And at the same time, it was brought to the attention of this court that there was a PU that had already been raised, which even the court was not aware of. So at the time we took a break, I was given a physical copy of the PO, and I was giving directions that the PO to bail and bond to be served to all the parties, and they are at liberty to respond. And at the same time, the application of 6th August 2025 to be served to all parties again, and an affidavit of service is filed, and parties are at liberty to file response, and if so wish, exercise their right to put in submissions. And I was asked by the defense counsel to give them time so that they would explore ways of building consensus out of court. So I've come back and I'm reliably informed that there is a consensus, and you're also on record as indicating that you have not been consulted. So if you have not been consulted, we revert to my earlier orders, all right? That the PO and the application of 6th August 2025 is served, affidavit of service is filed, and parties are at liberty to file response and skeletal submissions if they so wish, and we mentioned the matter in 2 weeks, 14 days. Counsel for ODPP, does that sit well with you?
Yes, my lady, that has been to find our own response.
The court will revert to the earlier orders as follows. A, the PO to be served to all parties through counsel, and in return, response is filed in court and served to all parties and counsel. B, the application of 6th of August 2025 is also to be served again and to all parties through counsel who may file and serve responses. Further mention on 6th of October 2025 on the bail bond application and the issue of legal representation of victims.